Hi everyone, welcome to the series of lectures on civil procedure. We now begin with the general provisions. Okay, so the topic for this course is the 1997 Rules of Civil Procedure. We will begin with the applicability of these rules. So to what actions are the 1997 Rules of Civil Procedure as amended will apply? Okay, so generally, it applies to all civil actions, whether ordinary or special. Okay, so what is a civil action? According to Section 3, a civil action is defined as one by which a party sues another for the enforcement or protection of a right or the prevention or redress of a wrong. Okay, so a civil action may be either ordinary or special. However, both of them are governed by the rules of civil procedure, subject to the specific rules provided for special civil actions. What about criminal actions, or what rules govern criminal cases? So first, a criminal action is defined as one by which the state prosecutes a person for an act or omission punishable by law. As a general rule, the revised rules on criminal procedure shall primarily govern criminal actions. However, as you will learn later, the rules of civil procedure may also apply in a suppletory manner in cases where there are no specific rules that may be applied. The resort may be had to the rules of civil procedure. It also applies to special proceedings. What is a special proceeding? It is a remedy by which a party seeks to establish a status, a right, or a particular fact. Okay. However, the 1997 Rules of Civil Procedure is not applicable to the following cases: election, land registration, cadastral cases, naturalization, and insolvency proceedings. Okay, except of course in a suppletory manner. What are the examples of ordinary civil actions? Ordinary civil actions, examples of which are specific performance, cases for damages, cases for collection of sum of money, declaration of nullity of a sale or a contract. So it is ordinary in the sense that they are generically governed by the rules on ordinary civil action, the 1997 Rules of Civil Procedure. On the other hand, what are the examples of special civil actions? Interpleader, declaratory relief, expropriation, foreclosure of real estate mortgage, and partition. Okay. Why are they called special? Special in the sense that they have special set of rules. Okay. Which is also contained in the revised rules of civil procedure. However, in so far as uh, nothing is provided in the special rules, the rules on ordinary civil actions may also apply to special civil actions. Okay? What are the examples of special proceedings? Settlement of estate, guardianship, cancellation or correction of entries in the civil registry, escheats or declaration of absence. So considering that special proceedings concerns the establishment of a status, right, or a particular fact, in settlement of estate, you're establishing your status as an heir. Okay, so in special proceedings, uh, the rules on special proceedings shall govern. Now, in a suppletory manner also, the ordinary rules of civil procedure can be applied. Again, What is a civil action? It is one by which a party sues another for the enforcement or protection of a right or the prevention or redress of a wrong. Okay. Ordinary and special civil actions, to reiterate, are governed by different rules. However, if there is no specific rule provided in the special civil actions, the rule on ordinary civil actions may be applied in a suppletory manner. However, again, there are exceptions to the applicability of the 1997 Rules of Civil Procedure. For example, those which are governed by the revised rules of summary procedure in civil cases, such as forcible entry and unlawful detainer cases, they have their own set of rules, as well as the revised rules of procedure for small claims cases. However, again, in a suppletory manner, the rules on ordinary civil actions may be applied. Now we have to also learn the distinction between substantive law and procedural law. What is substantive law? Substantive law is content law. Okay, it creates or defines rights, okay, concerning life, liberty, property, the powers and agencies of government for the administration of public affairs. Considering that it basically deals with the provision of rights, it operates prospectively. So from the time of its effectivity onwards. On the other hand, procedural law are those which prescribe rules and forms of procedure so that the courts may be able to administer justice. So it concerns with the rules to be applied once an action is filed in court. Okay. Rules of procedure must always yield to substantive law because the purpose of procedure is to give effect to substantive or content law. Okay. We now start with the case of Mijares versus Ranyan. So this case involves the enforcement of a judgment for damages which was given to victims of human rights violations during the martial law period. So the U.S. Court of Appeals issued this judgment. The judgment already became final and executive. So the petitioners were trying to enforce this final and executory judgment. So what did they file? They filed a complaint for the enforcement of a final judgment. Now, the Marcos estate moved to dismiss the case on the ground that the petitioners were not able to pay the correct filing fees. According to the petitioners, the filing fee should be based on the amount of damages that they are claiming. On the other hand, the petitioners are claiming that an action to enforce a judgment is one which is incapable of pecuniary estimation, and therefore the amount of docket fees would not be based on the amount of damages that is included already in the judgment. So what did the Supreme Court say? The rules are silent as to what initiatory procedure must be undertaken in order to enforce a foreign judgment. But there is no question that the filing of a civil complaint is an appropriate measure for such purpose. A civil action is one by which a party sues another for the enforcement or protection of a right. And clearly, an action to enforce a foreign judgment is in essence a vindication of a right proceeding either from a conclusive judgment upon title or the presumptive evidence of a right. The subject matter of an action to enforce a foreign judgment is the foreign judgment itself and the cause of action arising from the adjudication of such judgment. So what is the cause of action for the enforcement of a foreign judgment? It is the awarded judgment itself. So the refusal of the defendant or the respondent to comply with the said judgment is a violation of the right of the plaintiff. So that is the cause of action. It is not the amount of damages that is already awarded in the judgment. So the amount paid as docket fees on the premise that it was an action incapable of pecuniary estimation corresponds to the same amount required for other actions not involving property. The petitioners thus pay the correct fine. Okay? We now go to the case of Borlongan versus Alviar. So in this case, Alfredo died intestate without any compulsory heir. So among the properties he left behind is a real property which passed on by law to his brother who also died intestate. So Lucy and Mina, who were the heirs of Alfredo, have been residing on the subject lot for more than 20 years. To their surprise, the spouses Borlongan were able to obtain title to the said property, believing that there was no reason to buy that property because according to Lucy and Nina, they inherited the subject land from Alfredo. On the other hand, the spouses Borlongan insisted that Alfredo died with two compulsory heirs, Pe and Dolores, who were adopted by Alfredo. That is the reason why they were able to acquire title over the said property. So, in order to vindicate the violation of their right, Mina and Lucy filed a case for the cancellation of the transfer certificate of title issued in the name of the spouses Borlongan. Now, the spouses Borlongan countered that the case should be dismissed because Mina and Lucy's rights as the alleged heirs of Alfredo should first be established in a special proceeding. So how did the Supreme Court resolve the case? Okay, is it necessary for Lucy and Mina to first establish their status as heirs of Alfredo in a special proceeding before they can file an action to nullify the title issued in the name of the spouses Borlongan? The Supreme Court said that in the case, citing the case of Treyes versus Larlar, the compulsory or intestate heirs may commence an ordinary civil action to declare the nullity of a deed or instrument and for recovery of property or any other action in the enforcement of their ownership rights acquired by virtue of succession. So without the necessity of a prior and separate judicial declaration of their status as such. So here, the ordinary civil action Mina and Lucy filed may prosper as their successional rights as collateral relatives of Alfredo are transmitted and enforceable at the very moment of his death without need of a separate judicial determination. So their cause of action as compulsory heirs of Alfredo to the subject property was transferred to them by operation of law upon the death of Alfredo. And there is no need for them to establish their status as collateral heirs of Alfredo before they can file an action questioning or nullifying the transfer certificate of title issued in the name of the spouses Borlongan. Okay, Ongchia versus Republic. Okay, in this case, the doctrine is in naturalization proceedings. Okay, the rules of civil procedure is not applicable. Okay, so it can be applied in a suppletory manner but not primarily. Okay? We have the case of People versus Cell. Okay, this is a seminal case because in this case, the Supreme Court categorically declared that although in criminal cases, it is the revised rules of criminal procedure that shall have primary application. Okay, in cases where there is no applicable rule to be applied in criminal procedure, okay, resort may be had to the rules on civil procedure. Okay. So this is a case wherein this is a case involving Mary Jane Veloso, the overseas Filipino worker who was sentenced to death, okay, in Malaysia. Okay. During the time while he was serving her sentence in Malaysia, she filed a case against Serio, okay, for qualified human trafficking. However, considering her condition, because she is a death row convict in another country, she could not go back to the Philippines and testify personally in open court. Okay, so in order for her testimony to be taken, the prosecution moved that the testimony of Veloso be taken by way of deposition through written interrogatories. However, the said motion was opposed by the defense. According to the counsel for the accused, it would violate the right of her client to confront the witnesses face to face. Okay, so how did the court resolve the said issue? The Supreme Court said depositions, the rule on deposition by written interrogatories is inscribed under Rule 23 of the Rules of Civil Procedure. The court holds that it may be applied suppletorily in criminal proceedings so long as there is a compelling reason. Okay, the Supreme Court had relaxed procedural rules by applying suppletorily certain provisions of the rules of civil procedure in criminal proceedings. In light of the unusual circumstances surrounding this case, the court sees no reason not to apply suppletorily the provisions of Rule 23 of the Rules of Civil Procedure in the interest of substantial justice and fairness. Hence, the taking of the testimony of Mary Jane through a deposition by written interrogatories is in order. Okay, so we now move to the case of Inodata versus Inti. So in the case of Inodata, the doctrine in this case is that in labor cases, the rules of civil procedure can be applied also in a supplementary manner. Okay? Just like in naturalization proceedings. Procedural nicety should be avoided in labor cases in which the provisions of the rules of court are applied only in a supplementary manner. Okay? We have the case of Asuelo versus Sameco. Okay, with respect again to labor cases, proceedings before the labor arbiters, as well as proceedings in the National Labor Relations Commission, okay, the revised rules of civil procedure will only be of supplementary application. Okay, can procedural laws be applied retroactively? The answer is yes. Okay, they can be given retroactive application since there is no vested right therein. Okay, it can be applied to actions which are pending and undetermined at the time of its passage. However, there are exceptions to the retroactive application of procedural rules. Okay, when the law itself provides that the statute shall only be applied prospectively, or when its application to pending proceedings would impair vested rights. But as a general rule, procedural rules can be retroactively applied unless it falls within one of those exceptions. Okay? To illustrate this point, we move to the case of UP versus Dixon. Okay, this is the case involving the fresh period rule under the NAPES doctrine. Okay, under the NAPES doctrine, previously, before NAPES, okay, if there is a decision, Okay, you have 15 days within which to either file an appeal or to file a motion for reconsideration or motion for new trial. If you file a motion for reconsideration, okay, on the fifth day, you only have the remaining 10 days to file your appeal. But under the NAPES doctrine, okay, from receipt of the denial of the motion for reconsideration or motion for new trial, you have a fresh period of 15 days within which to file your appeal. Now, can that NAPES doctrine be applied retrospectively to those cases which were pending, okay, at the time of, or which to those cases which were pending before their issuance. Okay, according to UP versus Dixon, the Supreme Court held the retroactive application of the fresh period rule, a procedural law that aims to regiment or make the appeal period uniform, to be counted from receipt of the order denying the motion for new trial or motion for reconsideration, where any final order or resolution is impervious to any serious challenge. This is because there are no vested rights in the rules of procedure. A procedural rule that is amended for the benefit of litigants in furtherance of the administration of justice shall be retroactively applied to likewise favor actions then pending. We have the case of Panay Railways versus HEBA Management. Okay, so this is a case involving non-payment of bucket fees. Okay, can the rules and procedural rules be relaxed in case there was a failure to pay the docket fees within the reglementary period? The Supreme Court said in the case of Panay Railways, statutes and rules regulating the procedure of courts are considered applicable to actions pending and unresolved at the time of their passage. Procedural laws and rules are retroactive in that sense and to that extent. The effect of procedural statutes and rules on the rights of a litigant may not preclude their retroactive application to pending actions. This retroactive application does not violate any right of a person adversely affected. Neither is it constitutionally objectionable. The reason is that, as a general rule, no vested right may attach to or arise from procedural rules. However, in this case, petitioner admits that it was not able to pay the docket fee on time. Clearly, there was no substantive right to speak of when the RTC dismissed the notice of appeal. We have the case of Rumbawa versus Rumbawa. Okay, this is another procedural rule. Okay, before there is a requirement in cases involving nullity of marriages on the ground of Article 36 of the Family Code for the parties to submit the required OSG certification. However, this was deleted, meaning that there was AM number 021110, which took effect on March 15, 2003, saying that there is no more need to submit the OSG certification. Can it be applied retroactively? Okay, the Supreme Court said the amendment introduced by AM number 021110 is procedural in character, does not create or remove any vested right, but only operates as a remedy. And thus, procedural laws may be given retroactive effect. They may be given retroactive effect on actions pending and undetermined at the time of their passage, and this will not violate any right of a person who may feel that he is adversely affected, in so much as there are no vested rights in the rules of procedure. As remedial measure, remove the mandatory nature of the OSG certification, it may be applied retroactively to pending matters. Now, how do you construe procedural rules? As a general rule, procedural rules must be followed. However, if there are persuasive and compelling reasons that would warrant relaxation of the rules, the person invoking the liberality must provide the court with the meritorious reasons why relaxation of the rules can be applied. Okay. Section 6 states that this rule shall be liberally construed in order to promote the objective of securing a just, speedy, and inexpensive disposition of every action and proceedings. They were laid down to ensure the orderly conduct of litigation and to protect the substantive rights of litigants. It is only when persuasive reasons exist that rules may be relaxed to relieve a litigant of an injustice not commensurate with his failure to comply with procedure, provided that there is an effort on the part of the party invoking liberality to explain his failure to abide with the rules. Okay? To illustrate this point, we have the case of AUB versus Woodland. Okay? Again, the liberal and flexible application of the rules of court is an emerging trend in jurisprudence. Okay, however, the relaxation or suspension of procedural rules or the exemption of a case from their operation is warranted only by compelling reasons or when the purpose of justice requires it. Okay. There have been instances when this court allowed a relaxation, but this flexibility was never intended to forge a bastion for erring litigants to violate the rules with impunity. A liberal interpretation can be resorted to only in proper cases and under justifiable causes and circumstances. Again, as a general rule, rules of procedure must be faithfully followed, except for persuasive reasons. They may be relaxed to relieve a litigant of an injustice. So in this case, the mere invocation of quote unquote the interest of substantial justice will not be sufficient to override the stringent implementation of the rules. Okay, so in this case, the leniency granted Woodland was merely anchored on substantial justice. It did not prefer the meritorious reasons to support the plea of substantial justice in order for the court to justify the relaxation of the rules. Okay, we have the case of Cabrera versus Nam. Okay, this is regarding the 3-day notice requirement in motions. That if you file a motion, you have to furnish the other party at least 3 days before the date of the scheduled hearing of the motion. So in this case, the 3-day notice requirement was not met, but the opposing counsel was able to oppose the said motion. Okay, can the 3-day notice requirement be relaxed? The Supreme Court said the 3-day notice requirement is not a hard and fast rule. When the adverse party was afforded the opportunity to be heard and has indeed been heard through the briefings, the purpose behind the 3-day notice was deemed realized. In such a case, the requirements of procedural process, due process was substantially complied with. Okay, we also have the case of SLU versus Covarrubias. Okay, so in this case again, there was a failure to pay docket fees on time and within the reglementary period. The docket fees were paid late. Without payment of the docket fees, the appeal was not perfected within the reglementary period. While procedural rules are liberally construed, the provisions on reglementary periods are strictly applied, indispensable as they are to the prevention of needless delays, and are necessary to the orderly and speedy discharge of judicial business. So in this case, Covarrubias offered no excuse for her failure to pay the docket fees in full when she filed her petition for it. Again, a reiteration of the general rule that if you are invoking liberality, you have to give the court meritorious reasons why you are invoking the liberality in the application of procedural laws. There should be an effort on the part of the party invoking liberality to advance a reasonable or meritorious explanation for his failure to comply with the rules. Okay? We now move to the case of GIPA versus Southern Luzon Institute. So in this case also concerns a deficiency in the payment of docket fees. However, the deficiency is only 30 pesos. Now, can the petitioner who was saying that it is a measly amount of 30 pesos, he is invoking liberality in the application of procedural rules. However, he did not proffer or advance any meritorious reason why he was not able to pay the measly amount of 30 pesos. So the Supreme Court said, the liberal interpretation of the rules of civil procedure there should be an effort on the part of the party invoking liberality to explain its failure to abide by the rules. Those who seek exemption have the burden proving the existence of exceptionally meritorious reasons warranting such departure. However, in this case, they did not offer any plausible explanation why they failed to pay the correct docket fees or why they failed to comply with the directive for them to remit the 30 peso deficiency. Instead, they focused on begging the court for leniency, arguing that the meager amount of the deficiency justifies relaxation of the rules. Okay, so that's it for the general provisions. Thank you for listening.